To my left and your right is Ron Cottingham. He is a lieutenant with the San Diego Sheriff's Department. In that capacity, he's worked just about every assignment and type of duty that you can imagine. More importantly, he is the current president of PORAC, which is the Peace Officers Research Association of California. He's held that position since 2003. Been unanimously reelected to consecutive terms. PORAC is the largest statewide association for public safety in the nation. PORAC currently has a membership total of over 775 local, state, and federal public safety associations, comprised of a total membership exceeding 60,000 members. As president, Ron was actively involved in this legislation, representing PORAC's membership and making sure that public safety officers' voices were heard in this process. Also on the panel is Mike Jarvis. Mike heads the labor negotiators in our law firm. He's an expert in public employee compensation, healthcare, and of course pensions. Also present is Jeff Edwards. Jeff is a senior labor attorney with the Mastagni Law firm. He specializes in complex and class action litigation involving any number of statutes, including the FLSA, the POBR, Firefighter Bill of Rights, Myers-Millis-Brown, and general labor relations and labor litigation. He also coaches at King Hall's Robert F. Wagner National Labor and Employment Law Moot Court Competition. I'm David Mastagni. I am one of the partners at the law firm. I work with Jeff and with Mike and often with Ron as well regarding a host of different labor issues, both legislatively and in terms of complex litigation. A little bit about the law firm. The law firm was founded about 40 years ago by my father. It specializes in providing comprehensive representation for public safety employees. And you can also sign up on our law firm blog, where we will continue to provide up-to-date information on the pension legislation, as well as other legislation and court decisions that affect public safety employees. So with that, why don't we turn to the second slide, Jeff? I want to talk for a moment about the issues that we're going to be covering today. I think I'll start with a statement issued by the governor after he signed the legislation. And this is a quote: "This is the biggest rollback to public pension benefits in the history of California pensions. We're lowering benefits to what they were before I was governor for the first time, and reducing costs by up to $55 billion in PERS and billions more in other local pension systems. Under the new rules, employers and employees alike are going to contribute their fair share of the costs, resulting in a more sustainable system." And so that's the governor's take on it. We're going to start with talking about the new formulas for new hires. We're then going to discuss what is pensionable compensation and what are the changes in those rules. We're going to discuss the changes in cost sharing, limitations on enhancement for what types of pays are included in your pension benefits. We're going to talk about special exclusions and new rules for industrial disability retirements. So let's start with the definition of a new employee. It's important to remember that this legislation makes some very important distinctions between what it defines as new employees and current pension plan members or existing employees. And as you can see from the slide, the definition of a new employee includes any employee who is new to a public retirement system, or an employee who's had a break in service of 6 months or greater. So does anybody on the panel want to comment on what the impact of this definition is?
If you're in a 37 Act county right now and you have reciprocity with PERS and you move to PERS after 2013, then you'll go in at the oldest tier, the lowest tier in the old system, prior to AB 340. So if you move from Alameda County, you go to Sacramento, right now you come over at 3 at 50. After January 13, you come over at 3 at 50 if that tier is still in place. You will not come over at 2.7 at 55. Perfect.
I did it.
And another point on this is that it's designed to couple with requirements for retired annuitants. So if somebody is out for 6 months of service and then they come back, they're treated as a new employee even if they had 30 years in before that.
All right, Jeff, I'm going to move on to the next slide. So this is one of the biggest aspects of the new legislation, reduced retirement formulas for new hires, and as the governor bragged in his statement, this rolls back the 1999 enhancements and actually takes public employees to formulas that are even below that. The key for safety is that the new highest tier is going to be 2.7 at 57. There's also going to be an option for 2.5 at 57 and 2 at 57. All employers with 3 at 50, 3 at 55, and 2 at 50 will move future employees to the safety plan option 2. Under the legislation, you go to the highest plan that is available under the new legislation, but it's still less than what you had before. And so maybe, Ron, can you explain to people what the difference between the old 2 at 50 option is and the new 2.7 at 57?
Well, basically, the new option, when you get to it starts at age 50. That was something they didn't want to do. It was a program that we negotiated with them. We thought that was the fair way to do it. And it incrementally increases to 2.7 at age 57. But if you leave at age 55, you'll have a 2.5 formula. Now, one of the things, and we know of some agencies and associations that have already negotiated 2.5 at 55 for new hires. So your new hires under that program would not come in at 2.7 at 57 because they have put a vision there that if you have a lower formula in there is actuarially equivalent to 2.7 at 57, then your new employees can go into that current plan. So you wouldn't have new employees coming in at a richer plan than you have your current employees.
Okay, one of the other aspects of this plan that remains in effect is that you still have the ability to retire at age 50, notwithstanding the formulas using the term 57, correct, Ron?
Correct, and well, that will actually come into benefit as you have an IDR retirement. It will do that a little bit better than it does now.
And of course, everybody knows that under all of the new formulas, there is a 3-year average, and so there's no longer going to be available the last highest year. Any other comments from the panelists on the formulas?
No, I think we do.
So let's talk about laterals. Laterals employed prior to 2013 moved to the latest retirement plan offered by the new employer prior to this legislation. So, Mike, can you give us some examples?
I just covered that with the Alameda situation. So if you're leaving, even if we move up to Lake County, if you leave Lake County, who has 2 at 50 right now, and you go down to Sacramento again with 3 at 50, after 2013, you will still go into the 3 at 50 plan. So if you have reciprocity, you're moving at the highest or the lowest plan prior to AB 340.
An important takeaway here is that it doesn't make a difference if you lateral to or from a 37 Act to a PERS or from a PERS to a 37 Act jurisdiction.
I think the only thing that the person has to keep in mind or consider is if you're going to lateral, if you're going to lateral to a charter city or charter county, then charter county is San Francisco right now. But you'll have to check because some of those do not offer reciprocity. So you would go into whatever plan they have.
I want to move to the next slide.
We've got one question here. I think we can answer before we move on. It says, is single hire steer still in effect for current members as stipulated in our MOU?
Single hire steer is locked in for new employees, so they cannot change that benefit. They didn't attempt to change it. If you have single highest year for actives, that's locked in. New employees will all be at 3 highest year. And then the second question is, if you're moving from 37 to 37, as long as you have reciprocity, you're good. So if you're moving from a 37 to a 37, and one of them does not have reciprocity, then you're going to come in at the 2.7 to 57.
That'd be a key thing to check if you're thinking of making a lateral move. Do you have reciprocity?
Oh, this is going to happen.
To reiterate one of the points we made at the beginning of the webinar,
try the mute button.
These changes are not going to affect existing employees. This is a perfect example. So let's talk about pensionable compensation caps. This is one of the centerpieces of the legislation, and it is misunderstood by a lot of folks. This caps the annual towards final compensation for new employees. It's $110,100 for employees who receive Social Security, $132,120 for employees who do not receive Social Security. It increases annually based on the Consumer Price Index for all urban consumers. But as the bottom of the slide indicates, the key distinction to keep in mind is that those are not caps on the amount that you get in your pension benefits. Those are caps on the amount of your income that your pension benefit can be calculated from. So, for instance, Ron, in a PORAC jurisdiction, is it ever even going to be possible to reach those maximums?
You know, we don't think so. That's one of the things that came up in negotiations, and for rank and file, that it would be doubtful that they would even now reach the $132,000 cap. And this is going to be indexed every year, and I'm not an actuary, so I can't get a calculation. Someone said in 20 years the cap will be at about $190,000. So most of our rank and file members would be under the cap. It's going to be high-ranking persons, chiefs, and sheriffs that are going to have to be concerned with the cap. The other thing that you can consider with this, depending on the number of years you're willing to work, is this formula is 2.7 at 57 your max, is your max year, but that 2.7 multiplies by the number of years you work. You have to be age 57 to get the 2.7, but you're not limited to 80%, 85, 90%. If you are willing to work the years, you can actually go over 100%. That's something that, so they removed the percentage criteria on retirement and just put it that your pensionable pay has to be under the cap.
Do you have any questions on this topic, Jeff?
We do. We just got a question in. Is retirement calculation an average of 3 last years or an average of 3 highest years?
Yellow?
I don't think that's been changed by the statute.
It is not. It's still at 3 highest years.
We've got another question. This is, are these changes subject to the normal bargaining process?
I think we've got 2 different arguments on that. The first, on the new employees, most of them are not. On the existing employees, we would argue that most of them are, and I think we're willing to take that time on. But some of them I think we're going to get through, and others I think are still going to be challenged.
Yeah, certain of the provisions, I think, can potentially raise contract clause claims where essentially the argument would be the government can't pass legislation that impairs existing contracts. The analysis is a little bit different for new hires as opposed to existing employees. That's probably a full hour topic for another day, so why don't we move on to cost sharing for new hires.
All right.
Okay, so this, again, is another central piece of this legislation. The new legislation requires employees to contribute a minimum of 50% of the normal cost rate. The employer cannot impose contributions of greater than 50%. And there's an interesting exception. Actually, this bears on the last question we just had, which says that contracts in effect on January 2nd, 2013 would be impaired by any provision of this section. That provision shall not apply to the public employer and public employees subject to that contract until the expiration of that contract. So does anybody want to take a whack at what that exception means?
Well, I think what that exception means is that if you are in contract into next year, or you get a contract before the end of this year, your cost-sharing provision will survive this rule for the duration of your contract, however long that is.
Ron, have you been able to ascertain from any of your contacts what the definition of the normal cost rate is?
The normal cost rate is based on your pensionable salary, and later on in the legislation you see where for local public safety, police, sheriffs, deputy sheriffs, they also cap at 12%. So they cannot impose more than 12% on it. And I think there's also an interesting concept to 7522.30F in that some people have already opined that possibly they could open up that contract for the new employees and start the cost-sharing process with the new employees now.
Interesting. Let's take a look at cost sharing for the existing employees.
And we actually have a question on that off the top. It says, is there a cost-sharing requirement for current employees? Will there be a requirement for employee current as of September 2012 by January 2018? I think that kind of gets into the meat of cost-sharing for existing employees.
Right, and I think this slide kind of answers that question pretty definitively. Employers are able to impose 50% of normal costs, but that provision doesn't take effect until January 1st of 2018. Really what this legislation does is it sets goals to reach that 50%, and it also includes a stick, which is that if you haven't reached 50% by January 1st of 2018, then the employer can look at imposing cost sharing on the employees. The converse of that is that prior to January 1st, 2018, there is an express bar on employers imposing cost sharing at the bargaining table. The law also requires, as the last bullet point there indicates, that the employer cannot pay any part of the required employee compensation.
We're getting a lot of questions about normal costs. Can we talk about that a little bit more?
Sure. Why don't you read the questions for us, Jeff?
Sure. We've got a question. Is the normal cost 12% maximum exclusive of the employee 9% share? And can you define the normal cost rate, meaning does that include employees' costs and employers' costs combined?
As we currently understand it, the 12% maximum for current employees is inclusive of the 9%. So if you're currently paying your 9, you've got 3 to go. The second question on what is normal cost shall mean the annual actuarially determined cost for the defined benefit plan of an employer expressed as a percentage of payroll. They're defining that if you're looking at a PERS statement, which is different than a 37 Act, it's broken up into current costs ongoing, past costs, and unfunded liabilities. The cost that we're responsible for is half of the employer normal cost, inclusive of the 9. So you add those two together and you get it. You can't just look at the employer rate, add that to 9. It's going to be a much higher number.
The important way to think about that distinction between the unfunded liability and the normal cost when the percentages are calculated is if you had a retroactive enhancement in the past, because there wasn't contributions that accounted for that higher benefit level throughout the history of the plan, then using PERS as an example, they amortize that over 20 years, and so the entire rate that's paid is largely the normal cost, and then there's an additional amount that is sort of a catch-up for the folks who got the retroactive enhancement.
I've got another question on that. It says, if the employee has to pay 50% of the costs, will the employer be required to pay the other 50%?
Yes. Quite simply, and actually the employer is not only on the hook for their 50% of the normal cost, but they are also required to pay the unfunded liability. The unfunded liability is and employer costs because they are actually, in a way, the plan sponsors their plan. The employee is only required to pay 50% of the normal cost, which again is based on your pensionable salary and benefits.
Why don't we switch to the next slide there for a second, Jeff, and we can, to follow up on that question, it could be that the employer has to pay more than 50% because the cost share is capped at, under PERS, 12% for public safety, that is police, local fire, county peace officers, 11% for other safety, and 8% for miscellaneous. One other aspect that's important to remember when we get to 2018 and the ability for the employer to impose those cost shares come into effect, it's not an automatic right to impose on January 2nd, 2018. It still has to be negotiated through the negotiation process, and the imposition is the same imposition that an employer can do once it's negotiated impasse and exhausted all impasse procedures. For folks under the MNBA, what that means is that before any cost sharing can be imposed, you have to bargain the impasse and you have to exhaust the fact-finding procedure.
I've got a question here. So if the employer's normal cost is 30% right now, the cap is still 12 and not 15.
For current employees, that's correct. So right now, current employees are capped at 12%. New hires as of January of 13 will be responsible for the 15%.
All right, 1937 Act cost sharing.
The distinction here is that there's some slightly different rules on the cost share for PERS jurisdictions and 1937 Act jurisdictions. Just like before this legislation, there's new rules after this legislation. And so what the statute says is that the contribution is capped at 33% above the applicable normal rate of contribution for local police, fire, and county peace officers, and capped at 14% above the applicable normal rate for local general members.
That
was an easy one. So let's talk about, we're going to focus on PERS here, and limits on enhancement, or essentially, how does this legislation change what is pensionable compensation? Remember, this is for new employees only, and the key points are laid out here on the slide. Any compensation that's paid to increase retirement benefits is going to likely be excluded. Unused leaves, means vacation, annual leave, personal leave, sick leave, or compensatory time off, are going to be excluded. Allowances such as housing, vehicles. One big difference is uniforms. Prior to this legislation, uniform allowances were included under the PERS system. Now they won't be. And overtime with some exceptions and bonuses. So, Mike, can you explain what the exceptions are? I mentioned there's some folks working 12-hour shifts that on an 84-hour schedule that have some questions about that.
The two biggest exceptions are going to be for 84-hour work periods. If you're working over 2,080 hours regularly scheduled, then that's still going to count as time worked and counts towards your retirement. Firefighters are the other exception. If you're working 2,920-hour hours in a calendar year, then there's going to be an exception for that. That's going to count towards your retirement. The other thing to note on here, the biggest impact for us is going to be the uniform allowance for new employees is no longer PERSable. That brings up a bargaining strategy. Do we want to negotiate away the uniform allowance so that it counts for everybody and roll that into salary, or do we just want to leave it alone so that we have two different groups receiving one benefit at a different tax rate?
We've got a question here. So what about roll-ups, out-of-class pays, holiday and lieu, etc.? Are they still included?
Yes. All special assignments, special pays that are not mentioned are still included. So the allowances is the one that's going to hit us the hardest. Overtime really wasn't changed. Unused leaves, that was mostly originally targeting 37 Act. They put it in CalPERS and rewrote the legislation for 37 Act. So for PERS agencies, housing, vehicles, and uniform are the three that are no longer going to count.
But there is some broad discretion given to the CalPERS Board of Administration. We're going to have to follow their decisions pretty closely.
And they're given authority to fill in the gaps and define some of the ambiguities in the law. So why don't we talk about 37 acts? So the compensation earnable is also limited for 37 acts. The source of the right to include different forms of compensation or remuneration in your pension benefits, if you're subject to a 37 Act county, is a little bit different. It's not governed by PERS, it's governed largely by Ventura, some other seminal legislation, seminal court decisions, and local retirement boards. Why don't I, Mike, you mind summarizing put this in English?
The biggest change for 37 acts is capping the vacation sellback to what's earned during each 12-month period of their final compensation. And right now, this reads as if it will affect current employees as well as new employees, which is the opposite of what the PERS language reads. AB's 340's intent was to focus on new employees for the anti-spiking, as they called it. However, I believe this will affect new employees, but we're waiting on clarification of intent from the legislature on this. So right now, as it reads, it could affect both current and new employees, but I think it's going to wind up being new employees only. Anything to follow from that?
No, I would agree with you because when we were working with this through the legislative process and these are the others out there, our and everything spoken was that everything really to change the current process would be for new employees only. It kind of came as a surprise when they said these compensation earnable 37 acts, and they didn't specifically delineate it for new employees. So it does appear, I would say right now where it's written, it includes all employees.
I think we had a previous question about contract clause and certain aspects of this legislation which are going to be subject to legal challenge. I would submit that if the 37 Act restrictions on compensation are intended to be applied, that's hot area that you're likely to see. Any comments on that, Jeff?
Well, I mean, one of the things that's interesting about it is just like with CalPERS, with the Board of Administration, has been given a lot of discretion by the legislature to fill in the gaps. Each 1937 Act board has been given a lot of discretion. And there's no rule that says they all have to make the decision. So I think we're going to see this playing out in the counties for at least the next couple of years.
There was a past question that I didn't answer real quick. Sac County said that they currently pay 4% for their employee share, and they're asking how the cap applies to them. My reading of that is that 12% would go to 15 or 16%. I can't quite see the number you have there. That's how I read that. So 33% above what's currently because they do see that as paid differently. Their levels of benefits are different between 37 and PERS agencies.
I think the other distinction between 37 Acts and PERS agencies, 37 Acts have tiered employee contribution requirements based on age, and I know I county. You start at 9.5% when you're under age 37, and if you come in at other ages, it caps at 16%. So if you look at that formula, 33% of 9.5 would be very close to the 12 point something. But if you were at county at 16%, then you have your multiplier will be 13%. That's 16%, and that would be employee share in union pay. Because it's new employees again, so they employ.
I think we've got a question with firefighters as well.
Absolutely.
It's question specifically everybody PERS or the 37 applies. So it does not apply to the 6 or 8 PERS and either under retirement system.
One point of clarification, metro fires are 37 Act
Somebody asked,
discussing PERS and also compensation.
That might be the previous articles about 120 charter cities. we started getting a lot of questions about how to charter city, and we'll apply to it. So the definitive part of that is if you're charter city CalPERS or 37 legislative control, so you are squarely under the jurisdiction of the legislation.
The question that came in, typically for service credit is not affected by this. So if you're saving up your 5 years service credit, that's affected by this law.
This is affecting using sick leave to increase your final comp. Right.
Yes, correct.
All right. Let's talk about airtime. So this is one of the big public relations points that the governor makes is legislation is going to improve the by airtime. Really pretty much speaks for itself. The legislation only takes place on January 1st, 2013. What's happening is if you're interested in airtime, you better do it now. You can up until that day. After that day, it will no longer be allowed. This is kind of a red herring in my view, given that you have actuaries figure out what the cost of purchasing airtime is, and so the drain on most circumstances, it's a net benefit. If you want to kind of get a little bit on economics and that sort of thing.
I think that they're really the financial advisor for you. I think that lower your salary, lower your retirement plan, and more probably for a lot of people. Hospital, I heard somebody got a quote the other day, $50,000 for your service. I don't know how that could ever pay off. So it's something that you need to do is sit down with a financial advisor, work on it, or buy it because it's going away, and make sure it's expensive.
One of the things also they have eliminated the ability to survive surface around like more trade. That kind of actually works, so you can still purchase those.
We've got a question here on airtime purchases in progress after January 2013 to be honored.
Yes. As long as you're out in and receiving prior to January 13, you're good. You're making payments on airtime. You've got to 5 years. If you've paid for it full, then all you have to do is get that request in. You don't even have to have a payment on the file yet, as long as they've received it.
And that language is really designed to be clear cutoff on the official application. So a day late, $1 short isn't going to work. It's really in a clear line that they can phase out processing those requests.
The Mastagni Law we don't wait until the last day. There's some feedback in the application where you submit it to the wrong person. You really leave yourself no time to make a correction.
Having not seen the application just came in as file the initial request for a proposal count. I would say you probably have to have an agreement to purchase the application and submit it and have some sort of acceptance for having the application they're using. So if you get your agreement received, as long as that's the application for the title should be good.
Any questions, Jeff?
No, on this issue, no.
This is another one that made a lot of headlines, but it's not really going to affect a whole lot of people. Felons pension benefits. It's not as broad as it sounds. Employees benefit that if they get a felony and that felony was made in the course of carrying out official duties in seeking elected office or appointment or in connection with obtaining salary or pension benefits. Jeff, you want to talk a little bit about when the cutoff is and how that forfeiture can play out?
Well, I think, the first thing, forfeiture is likely to drive constitutional challenge for existing employees. This certainly is an area that's been flagged in a lot of legal discussions, likely to be a constitutional challenge. So there'll be one that will be brought by some individuals subject to forfeiture, right? Mike, is it 6 years? Or it's the 2010. So the start date is based off of the current conviction, and so you can imagine if someone's charged with a felony, the events leading to that occur along with conviction, and then that dispossesses their right following that date, and limits their service credit going forward. So it's really about the event, essentially in most cases, something like this, but, or a conviction by jury trial. There's no clear incident date.
Two other points. One is there may not be discovery for a year or 6 months. That time also doesn't count. But you're making contributions, and that anything that you contributed will be returned without interest. Once that cutoff date is set. So you'll get up to that cutoff date, and then you'll get that money back after that without interest.
Yeah, that's a good point that I think a lot of people don't realize. Not forfeiture and benefits. Any benefits that accrue up to the date of the commission of the felony still remain regular employees at the retirement age. Any questions?
We've got some questions about some other topics we probably address here before we move on to the next issue. We've got a question. If your current MOU expires in 2020, does any of this affect current employees?
Hi, John. The answer is doesn't look like the cap of what is pensionable may, and right now that needs to be sorted out. So right now in Alameda County, you can use a lot more than 1 year's worth of accrued time, vacation time, and so back and fight your pension. That and this law would be allowed to be one accrual for every year that you use to calculate your final comp. If that gets hammered out in our favor, then that means that through 2020. If that gets hammered out against us, then there could be some effects. We'll have to play that out. But right now, I think we're pretty good standing through 2020.
Now, the language on the cost share says 2018. I think that was really designed thinking who could have a contract after 2018. Who could possibly that's so far in the future we don't have to worry about this issue. But there will be a few jurisdictions where that's an important issue, and they end up leading to court charges.
I think the most there has to be bargains that have to go through the account. So for an employee contract, I think we've got an argument that A, we don't have to bargain, and B, the employer may require us to pay even after that point. We may be fine between 18 and 20.
That circumstance may be a contract clause challenge as well, because you can give and take as a bargaining process, exchange for maintaining the benefits at a certain level, contributions at a certain level. There's elsewhere, other payer benefits that we have received, for the legislature and the governor to come in and say, let's do that contract without giving some other greater benefit. I think does raise constitutional issues.
Can you talk about that?
That means where those employees coming in are under the mandated cost sharing.
They already have cost sharing in place, so they would be protected until that contract expires.
So you say it's doing what contract.
We may negotiate with the employees so we can lower rate, be a higher rate, and then we'll I'm gonna leave it alone. So right now, based on law, if you're in contract, if you have cost share, then you're protecting their.
And that concept goes across the board. You know, somebody either goes now or decides to do a strategic and limited or open or do that, they could skate in and get some sort of cost sharing and long-term protection. The statute's clear. It's whether or not you have a provision effective at the beginning of 2013, so there's still some time to get that. Employers are going.
My favorite on a very topic there, delve a little bit deeper. Do you foresee where the legislation may require new employees and more than they otherwise should?
Especially I do. Right now, I think if you're small, you're looking at having very different rates. So if you're full, you're coming in and 355 or 350 or possibly even that low, they're going to have their own blended rates for those previous safety formulas. The new employees are going to come in at probably full value, only 20 to 25%. It could even be a little less. So right now, the law says that they would have to blend rate, then they could be paying somebody put up about 20% contribution, a new employee paying 20% for benefit of 19 or 20. And that is a way of paying for benefit and funding what they're paying for. So if we could, we could negotiate that so that they're paying their appropriate rate. If you're in a larger agency, there's costs that are paid on the gate. So if the employer contribution is full normal contribution is 20%, active employees are 12, new employees 20, instead of half of their actual plan. So I could see trying to get in there and negotiate early if it benefits them.
All right, we'll watch our last slide, and then we'll put out some questions over all the topics we've discussed today. So industrial disability retirements. There's some rules under the legislation. These rules sunset on January 1st, 2018. I don't know why I guess that's a magic date for some reason. Here's the interesting thing is, for a lot of public safety employees, the new IDR rules are actually going to be a benefit. Ron, you want to explain why that is?
What they actually wanted at the table during discussions on this. This kind of brings CalPERS to the level with 37 Act, injury, but you're under age 50, but you're retirement age. What they do is 737 Act, is get over 70%, we're asking for 60% or 70%, then you get 50% tax free, but you also get that additional 20% tax on part of your pension. CalPERS is now 2018 same guideline where if you injured and retired 50, say you paid it at 80 and already had it on years, bringing over 50% pay, then you're 60% tax free, and then you get you 70% instead of 10%. This sunset that they want to look at and see what financial damages may do CalPERS or financial liability. The legislature has the ability at any time before the sunset to waive the sunset and think that it won't get benefit.
But fair to say this is going to be a significant benefit for disabled employees for the PORAC system.
And I would say this change in law will not just going to be new or new, but will occur in all the change they got in our IDR requirements.
Which did you have on?
All right. Any questions we have on that?
I've got a question on an unrelated issue here. Can you talk a little bit more about contract laws?
Certainly, that's one of my favorite topics. Litigation management topic for quite a while. What the contract law basically says is that the federal state government can't pass laws or resolutions that impair or break financial obligations of governmental entities. So, in other words, most obvious example would be if a government entered into a collective bargaining agreement with you and said it's expensive, I want out of it, they can't just pass a resolution that says, I declare a physical emergency, I'm now no longer bound by that contract, and I'm going to negotiate. How that plays out with pension reform, it's actually a number of different ways. We have one would be to say that it impairs the bargaining agreement because you're negotiating for a level of benefits for a period of time, and they're now having intervening legislation that says you can't have or you bargain for. And then the other would be on an individual basis, say that a member of the retirement system based on actuarially numbers and percentages that are intended to determine what their level of benefit is. If they're not paying anything, you still are because all of the regions or even the CNC where people are paid fully portion. That's in lieu of other compensation. And so for that reason, there's an argument that the employees of the system, they perform substantial work, exchange for these benefits, and then to the extent that they're taken away from them in the middle of the game, the rules are changed, that violates our contract clause. That second issue is primarily being a claim for the existing employees who've already performed substantial work, and paid into the either directly or through compensation. The claims based on impairment of the collective bargaining agreement are going to apply to everybody because the employees that are hired yet are going to be subject to the collective bargaining agreement that is currently in existence, at least until the day it expires.
Got a question here on IDR. It says, can you explain the actuarially reduced factor?
I think there's three questions there I can wrap up all at once. Bullet point 3. Currently, if you got hired at the age of 18 and safety, you've been here 30 years, now 58. If you retire under CalPERS, you're going out at 50%. What number 3 allows you to go out at not 90% insurance, I don't want to be thinking on your 2 more years, but an escalator or a de-escalator. So it's up from 50, but de-escalate down slightly. So let's just say let's drop all the way down to 7. You're going to retire at 81% of your pay, 50% tax-free, 31% taxable, and that's 31% greater than the current benefit. Do the rules apply to firefighters already retired? No. Retired, they don't change. And then all three of those.
Question.
Why don't you go to the slide, Jeff? Can open up the questions.
Actually, I have a question on the contract department and terrorist system. How does that affect the city is lived in and if it's granted bankruptcy?
And then it's
That's the issue that in the arbiters have their way. Without giving a seminar on bankruptcy, the key thing to remember is in a bankruptcy, only the city or county or such district can determine what obligation to discharge in the bankruptcy. In Stockton, we're talking about the city has acknowledged that if it tries to discharge its pension obligations, it won't be able to field the police department, the fire department, and probably using municipal government, and so it hasn't done so. It's also recognized that you can't just look at one aspect of an employee's compensation. You have to look at their entire compensation package, and clearly they're taking 30% reduction in pay as active employees. They've been forced to do more towards their pensions. Part of that process, they've had their pension benefits reduced because their compensation earnings have been reduced. And They've had a retirement benefit eliminated entirely because it needs benefit to the PORAC pension, at least in that jurisdiction. And so what happens in bankruptcy is there are two ways that bankruptcy plan challenge, but only the city and county can propose a bankruptcy plan, and challenge the eligibility by saying that the agency is broke. You can also challenge eligibility by saying that they didn't negotiate the creditors, right, being impaired, and appealing the process, they can say that the plan of a judge is not there, and that you need to come up with a different plan. But there is no process for your own bottom line decision and say you have to go after the proof. And the bottom line there is as long as the city keeps the pension off the table, it's not going to be an issue that needs to be adjudicated.
There's a few questions that and like the answer on restraint. The first one is if you just bargain second tier, does this wipe out that second tier? The answer is yes and no. Anybody that's hired new after January comes in at 2.757. However, new tier is applicable to lateral persons who are currently employed. The lateral question also was asked if you're in a non-sworn unit and you go to sworn or non-sworn to another sworn agency, does that count you as an employee or an existing employee? If you're in a system, you're in the system, you're not an employee. You don't have to be in safety. So if you're in a police unit, you're CSO, and later you become a police officer, then you're coming with the lowest of the old tiers. And then lastly, if you're out of contract with your 450 employees. No, they cannot impose 50/50. They can impose they cannot impose that you pay more than that. So if your first agency impose up to 9%, they can't impose greater than that.
The legislation is very specific on that point. The right to impose doesn't come into effect until January 2018. What the legislation is trying to do is create an incentive for the employers to bring it up at the bargaining table and for the employees to negotiate early so that you don't get into that situation where there's potentially being imposed on. The other thing we can look at from a bargaining perspective is if they can't control that, they can come out for something else. And so one of the things that PORAC and really all of the legal groups were pushing for was to have methodologies as part of the bargaining table. The legislature didn't give us as much time and ability to negotiate these things as we would have liked. That's one area where they didn't give us 5 years in reading room and try to negotiate.
A couple other questions. Somebody asked the it does not prohibit on service. If you have prior military time, by that, you can't purchase time for the sake of purchasing time. What is it? That is probably one of the changes a lot of we're not happy about. The employees no longer not fund your retirement. So they try to say you fund your retirement when we know they put over a decade off in some cases. They can no longer do that against the law. They have to make the payment. That's a lid. At least they have to make the normal. They don't have to make their own funded. They have to make the normal ongoing.
Hopefully, CalPERS, we'll get into this job again. I mean, that's really the sense. That's the problem.
You remember back when the birds were funded?
Yes. Actually, 70% of the state will pay 0.5% of that period of time, and I think about 35 was over 100% funded. And at that time, and think the normal cost payment that again, as the legislation changed, when 100% funded, obviously, you're covering another liability, so they don't have that space. There's still required ongoing cost in you for now they got to take that holiday.
Guy on the far right, he is the president.
I'm not sure if the question on airtime was still answered.
Hello?
That you should know is explained earlier, if your current employee can still purchase airtime and get that airtime, all application in January 1, 2013.
Lead me to believe
So it has to be in by that day. Everything else after that would be process. That would not be looking at it. If you decide on January 1, 2013, you want to apply for airtime, you're out of line, you can't do it.
So I've got a question, Ron. Where do you see the legislation headed that the legislature was back with session correct, and we've been giving the law?
We've already had discussions, staff, and members of the Congress are really doing legislation, and specifically, we're talking about cost sharing, which is new employees, current employees, there's two different sections of this. So we are going to be having back with some legislation, some language, and some of it we might have to ask for the new legislation come back in December, first week of December, after the election, when the legislation was in on the 20th. So we could talk about legislation at that point. If your city or county is looking at skewing things a little bit later, that is legislation off, to put up the ambiguity and that in time, legislation can get some legislative intent, I guess, descriptions from them, say this is our list. Here, this is our intent. And intent will also help in marketing. We could either only get our contract on January 2013. So that's a two-pronged solution going forward. Language, clarify, and also then we try to solve some clarifying legislation in the first week of December, which we first see place with the key. So hopefully we'll get that done. And there's another area that provides some clarification is the analyst on how they came together index section and how each section should be applied. So hopefully next couple of weeks we might get some more clarifying information from the legislature on how this is going to work going forward.
We're getting a lot of questions about post-retirement, retired annuities, somehow we get around the limitations, and somehow we enforce it.
This is something
I just have that question.
Last year, 80, 28, years ago, which limited hires specifically that we have the right. Didn't limit files so much, you got two separate sections, but it did limit executive positions, one 900-hour period of work is out. And again, that had to be done very quickly. We came back to the SMSB 2021, which was language for Calvin, which was part of the budget favor bill, and they reclarified it again, so their time. That now is kind of brought into new section. So if you are an employee, you can apply to work 960 hours in your system, in the other system, without being paid in the tax system, for public safety, police and fire, no 180-day prohibition. You can work the next day. And 960 hours each fiscal year. That's important beyond that. And you can't go from California 77 Act another 90 hours. You can only get 960 hours cumulative in a fiscal year. Exception that was to work a full year, but that's it. They've done that. The language and file, he's just fiscal years to us with the CalPERS and the other systems needs consecutive years or more than 1 year. One of the other things that is brought into this is higher on the disability. You cannot go and work in the same or similar position in any other retirement system. So they retire by peace officer from a CalPERS agency. You cannot go to work as a deputy sheriff and some of that county. But you could go to work as an operations specialist, dispatcher, and evidence technician. You cannot go back to work as a state position.
So it looks like we are running out of time here. I do want to thank Ron Cottingham for being here with us, and also thank Ron for all of the hard work that he does to running for public safety officers, saving and several other states. And we want to invite all of our webinar viewers sign up for our blog, email update, and we will keep the things coming as information becomes available on this legislation and other issues that affect you. You can also look at the PORAC website for similar kind of information. Any other final comments from the panelists?
No, that's the basis.
Well, actually, one other comment, and this is specific to the 1937 Act, there's 20 1937 Act. Each one of them operates under the legislature, but each one operates a little bit differently. Some of these things are dependent on how your individual 1937 Act interprets and how they interpret earnings and how they might interpret cost sharing. And the thing that I would caution you looking at that it is one of the normal costs, not other actuarial liability. So you need to make sure when you're looking at cost factors that you work with them to get just the normal cost, and when you're sharing that, the percentage of your employee contribution requires consistent in the operating.
Appreciate it.
And we've already seen that. I've collected a couple of preliminary analysis on 1937 Act already, and I can tell you that each one of these is just a little bit different than the other. So that's a cautionary note.
And if anybody would like copies of the materials to share with their members, coworkers, just shoot us an email, we'd be happy to provide that information.
There were four questions at the end that I think I can answer pretty quickly. Yes, there's a scale from 51 to 656. It's in the law, but if you pick up the 8340, you can see what that escalator is. There's a question, if you're making over the cap, can you invest in a difference? If you're currently making over the cap, it doesn't apply to you. The cap only applies to new hires, so I wouldn't worry about that. And then the question on is it's going to cost allowing to hire employer costs on lateral. I don't think so. Because there's a lot of departments out there that want more experience. I've got departments that still have them that want laterals only or institutional hires. And other departments are going to look after themselves. So we're going to see a wide spectrum of results there. And then lastly, all of the entities that you have as far as CSI and other benefits related to assignment all still count, and those are effective.
With that, I'll thank everybody for attending, and we also will be having another webinar coming up shortly on GASB and the accounting rules that be applied to mention and the effects that's going to have on your financial statement and at the bargaining table.
Thank you.